Our speaker today is Charles Chips Lickson, JD, PhD, from Front Royal. He's a practicing attorney, a former practicing lawyer, mediator, writer, trainer, and associate professor of political science at Shenandoah University. He's the author of many magazine articles and 8 nonfiction books. His Ironing It Out, 7 Simple Steps to Solving Disputes, was originally published in 1996 and had worldwide sales. He's published extensively on privacy issues to both lay and legal readers. A list of his publications can be provided. An updated version of Ironing It Out, dated 2020, is available on Amazon and Kindle.
Hello. In anticipation of speaking to you, I started to cough. I don't know what that means, but I'll get through this anyway. So, why privacy? Question mark. That's the title of this service, this presentation. What question mark? What privacy? Question mark. So this little talk is designed to summarize what is still included and what is not when privacy is an issue. I learned this morning that the slides that we had sent, that I had sent, are not available, and that's good news and bad news. The good news is I can talk about stuff that isn't on the slides. The bad news is I don't have the slides, and my talk is around and based upon the slides. So I do have a slide presentation here, and I'm going to pretend that you see it, okay? So the first thing was who I am and so forth. You heard a little bit about me. I'm no longer at Shenandoah University, having moved on for age reasons, and also to devote a lot more time to our little firm based in Front Royal, Conflict Management Consortium. And we work really literally all over, but most of our work is in, pardon me, Front Royal, because I am a firm believer that to be successful in mediation, you should be present with each other and present with the mediator, co-mediators. But it doesn't always work that way. So consequently, we have had cases where parties have been in different time zones, which is a bit of a challenge, and in different countries, which is a bit of a challenge. Anyway, so privacy and the computer age, the IEEE Spectrum magazine, I know you're not going to believe the year, June 1968, had my article, and it went out at that time to 300,000 electronics engineers and others who were involved in the creation, basically, and collection and dissemination of data. And I'm using it as a basis for the talk today because I want to look at what privacy was then and what privacy, question mark, is today. So that's the title of my article. The article is over 15 years old and it's still occasionally cited, which is amazing to me. In fact, in a publication on cybercrime dated 2012, it referred to the dramatic difference between when I wrote and when this person was talking about cybercrime, but it referenced the same thing. What are computers like in the digital age, and what will happen to all of them and all of us? So let's see. As counsel for a company at that time that serviced the information in the financial community, and it was much smaller than IBM, but with IBM Computer Services Corporation, National Cash Register, NCR, and so forth, all the big names in the late 60s, early 70s, got together as an industry called the computer business industry to look at the interrelationship of computers and communications, and give a report on whether or not there should be legislation that covers the interface of computers and communications. We'll come back to that a little bit later this morning. In 1968, and since I've written several articles and a treatise for the legal field entitled "The Use of Alternative Dispute Resolution in Intellectual Property, Technology-Related, or Innovation-Based Disputes." Now, I don't know what the circulation was, but it was written for Lawyers Cooperative Publishing Company as part of their trials publication, which is an encyclopedia series, mostly for supposedly trial lawyers and other lawyers. We had a copy when I was practicing many years ago in Connecticut, which I would say, because there are several former Connecticut people here, now proud Virginians. But of course, we won't be accepted as Virginians if we originally can. But anyway, what has happened to sort of leave my script aside? I sound like a politician for some reason. Leave my script aside and talk from the heart. No. I'll tell you how I really feel about issues. No, don't worry, I'm not going to tell you how I really feel. Privacy is used in the concept of, it's really been creative out of a concept that goes back to 1890. And believe it or not, there is no right of privacy that is part of the Constitution, still been called a basic right by many people. As I use the term, we only go back to 1890, and we just have to acknowledge Justice Brandeis and Samuel Warren for an article which created a right of privacy, academically speaking, that became a resource for many courts and other observers to incorporate the right of privacy into our lives, such as it is. And where that came about was actually the marriage of Mr. Warren's daughter. There were photographs, which were fairly new at the time, but they were not. They did not seek permission of the parties to take photographs, and that created the right to be alone. So privacy in its early term, or its early identification, definition, was the right to be alone. Because Mr. Warren felt the marital party and so forth had a right to celebrate and be alone. So it evolved such as it is from there. Let me say something about the way I'm addressing this, basically off script. And the reason I did write the script is because I intend to write an article on privacy today as a follow-up to my earlier article when I first talked about it in 1968. Actually, it was before that. In 1967, I believe, my first article came out in the Computer Group News, which only went to 50,000 computer engineers at the time, and it was seen, and Spectrum magazine decided that this is of interest to all engineers, and it has triggered the interest of a number of people since. But when we think of privacy today, we think of the protection of the individual or organization from unauthorized interference or interception of private communication by any means. Very important, because a lot of the early cases had to do with wiretapping, listening in, viewing, and other means of connecting to a conversation or a meeting without authorization. And the unauthorized access to personal or confidential information in the hands of the individual or another. The general method of assuring the confidentiality of data in the communication flow or in storage are these considerations: moral, legal, and technological. Very important, because with the proliferation of computers, data collection, and now data centers. So these data centers, in great measure, I have to back up just a second. My little former company, it was not mine, I assure you. Actually, Martin Marietta owned our company, but they created the ability for stockbrokers to have on their desk a device which had the latest quotation. And as I recall, since I handled as a lawyer, many of the leases, we had 1,200 locations. At the time, I worked for the company was called Bunker Ramo Corporation. We were, as a company, the largest user of AT&T long lines, exceeded only by NORAD, the North American Defense Communications industry. So it was a private network, but it was a network. And it was, if you can see, the forerunner of what we have and don't even question today, and that's the ability to get online and basically communicate with anyone, anywhere. So there are limitations and issues that arise when we have this interface. And what I was going to say, and why we heard that music in the beginning. The first music, of course, thanks to the board of directors of our congregation, I was at a little bit of a loss to introduce music as the concept with Gary's help, etc. And someone said, "Why don't you use Inspector Clouseau?" And that's that wonderful group sound that we heard was the music from the Inspector Clouseau series. Then the other music, which introduced our little talk, was the song "Alone Again Naturally." And that I did pick by title, because the litigation or the situation in 1890 that caused Justice Brandeis, he was not a justice at that time, but he became one of the more distinguished, most distinguished probably, of American justices on the Supreme Court, was they were not alone at the wedding, and they resented that fact. So aloneness, the right to be alone, was a pivotal right. I can tell you that many, as I said before, many of the earliest cases grew out of the criminal litigation field. They were basically the accused objecting to the way the government obtained the information, whether it was a wiretap, in some cases drilling through walls and getting a picture or a photograph. There was something called a spike mic, and that was a microphone that could not be seen on the other side, but picked up sounds and so forth. The law enforcement industry, and I might add parenthetically and personally that when I came out of the Army, I did go into law enforcement for 10 years, but I was a practicing attorney, and law enforcement attorneys. I was chief of the auxiliary police department in Stamford, Connecticut. By law in Connecticut, auxiliary police were sworn officers and could carry weapons, and we had the full power of arrest. I don't know what the status now is, but anyway, we were very, very concerned, all of us, and all of us should be concerned about government and law enforcement and anyone listening in where they're not permitted to listen in. And I'm going to stop for a second and get your thoughts about this, because in mediation even, we say the proceedings are confidential. We don't talk about the right of privacy, because privacy is more a macro concept. Confidentiality is a more micro concept. And we don't guarantee privacy, we do guarantee confidentiality. And we do that with the parties. So do lawyers, doctors, and so on and so forth. When we go so far as to keep others out of the mediation space, because the introduction of a third party who has not signed on to a confidentiality pledge eliminates the confidentiality for all, for the proceedings. A lot of people don't know that. So anyway, I talked about the criminal law, but there also developed after the Brandeis-Warren article a tort. The word tort, if you don't know, is a non-contractual wrong. It's a legal, an accident, that kind of situation, negligence, those are torts. So there is a tort recognized for a breach of privacy. Well, that's pretty good. So not only did it arise as a right, and especially the rights used in criminal cases, but now it's can be used in civil cases in violation of your right to privacy. So I'd like to pause for a second or two and hear your opinions, or comments, or questions. Or you could do what happened the last time I led a webinar at the Virginia Mediation Network, hour and a half of my time, in which I designated specific comments from the audience. There were none. So I ended up, I wouldn't say making it up, but I didn't sing or anything like that, I promise. But does it, I'm amazed a group of us, Unitarians, thinkers, wouldn't have necessarily views on what's happening to us and what is happening to privacy today. So we now know that there's tremendous data collection, and the data collection centers have the ability to talk to their clients, obviously, but they can communicate with each other. So it is the ability of get passive information. And you have heard and read a lot about, and maybe even been the victim, as we have, of a data breach, which raises a tort, an invasion of privacy, because a bank or whatever it might be has data about you, personal data, could be a doctor's office or what have you, or an insurance company, and their collection of your private data, which was not for dissemination, finds itself disseminated to people who don't have the right. So it's an extension, really, of the right to be alone, or the right to have only authorized persons or organizations, which you choose, get your information. We live in this world, and data breaches are happening all around us.